Good morning and welcome to another episode of Saturday Morning with Sam. I'm Sam Gaylord, managing partner at Gaylord Pop and disability litigator in the state of New Jersey, representing injured workers in the areas of workers' compensation, Social Security disability, and disability pension appeals. And I want to say good morning and welcome to everyone and Saturday Morning with Sam. Thank you for joining me, and thank you for everyone who has been participating in the last several weeks. We've had a lot of great questions and have been able to really get some good information put together for everyone in just the areas of workers' comp and Social Security. We've been talking about those the last couple of weeks. And so I wanted to, first of all, obviously I am not in my office. I had the chance to had to go out of town for a day or so, I am in the woods, as you could see. I first of all wanted to also thank everybody too for sharing the episodes, because last week again we almost had 1,000 views, and to me that really is awesome, because it really and truly is information that, as I see more and more people having access to, getting smarter with what needs to get asked and the answers to questions that really need to occur. So thank you for sharing. I appreciate that. And so today I wanted to briefly discuss with everyone what it's like to be in workers' compensation court, and to talk about, hey, good morning, Loretta, and talk about what goes on to give everybody a maybe slightly better understanding of the sort of the conclusion of a workers' compensation matter. After you have gone through most of the process and been evaluated by a doctor for both you and your expert and the expert for the insurance company, what happens next is that the matter then gets listed in front of the particular judge. So to give you an understanding, every single case that's filed in the Division of Workers' Compensation, every single case, there is a judge that gets assigned to your particular matter, and that judge will be the same judge who will, unless they get moved or whatnot, but for all intents and purposes, that judge becomes your judge who will eventually make a decision, or who will eventually place the matter on the record for purposes of settlement. So once you have been evaluated and both sides have their medical reports, then you go to court and you'll sit in the judge's chambers. Some judges will, in the morning, they'll call their list. And what that means is that there's usually anywhere from 50 to 75 cases any given day that the workers' comp judge is going to handle. So they usually will sit in chambers, and they will, some cases aren't ready to discuss. Some cases the people are still treating and whatnot. So the cases just get adjourned, and they are sort of informational. So, hey, good morning, Chantel. And so they're, it's sort of information for the court to just let them know exactly what's going on. But the cases that are ready to conference, you will sit there and then discuss the case with the other attorney, and the judge is listening. And sometimes, hey, good morning, Bertie. Sometimes the case can resolve very quickly in the sense that it's very straightforward and both sides sort of agree to what's the value of that particular case. Sometimes you have to involve the judge, so you'll start to talk about it with the other side, and it looks like you're not really going to get anywhere for whatever reason, and so it matters that you get the judge involved and you can explain to the judge exactly what's going on and why your particular position, hey, good morning, David, why your particular position is right or closer to what it should be in terms of the value of the case. So when, hey, good morning, Brian. So when you start to discuss the case, you're in chambers, so it's a little less formal than being, let's say, in open court on the record. It's an environment where you can discuss the medical documentation, discuss, as an example, if somebody, let's say, has a problem with their neck, was there an MRI that shows that there's a herniated disc? Was there other tests that were done that would demonstrate what the nature and the extent of the disability are? Or is it a situation where the person got some physical therapy and that's about it? The value of any particular case is based on not only the treatment that somebody receives, but the impact of the injury itself on how they are able to not only do their particular job, but also how they are able to also do things, let's say, around the house, or activities that they used to do that they can't do now or have more difficulty doing now. And you want to sort of accentuate those things because that helps and demonstrates the value that the matter should actually resolve for. But workers' compensation conferences are, again, informal. They are done with the purpose of trying to move the case forward. The attorneys who come to court for the insurance companies, though, they usually don't have direct authority. Again, depends on the insurance company, but for the most part, they don't have direct authority to say, okay, well, we're going to settle at that. So what happens is you'll have this conference, and you'll leave the conference with a understanding of where the value of the case might wind up. And so what then will happen is the attorney for the insurance company will go back and she'll speak or he'll speak to their adjuster, and they will get authority to make an offer, whatever that might be. Now, remember, in workers' compensation, the value of a case is based on what are called percentages of disability. So when we're in workers' compensation court, we're not talking about dollars and cents. We're always talking in terms of what's the percentage of disability. Now, the advantage, of course, is that, or I should say the thing of it is that you know that the higher the percentage, the greater the dollar. But the discussions are always held in terms of what is the percentage or what's the value of the case by way of percentages of disability. So the conferences are held, and then the attorney for the insurance company will then go and get authority. They will get the authority and make an offer, and then the attorney will sit, and what we do is we'll try and bring the client into the office, or we'll provide notification of exactly what's going on. And then the case will, if it's something that we want to accept, the case will settle in court. And if it's not something that we want to accept, we'll go back and, again, at that point, have to have a more in-depth conference with the judge, because if it's not an offer that we're willing to accept, then the alternative is either to reconference the case and potentially have the judge input, which would change what it is that they're offering, or just indicate that from a resolution point of view, we can't get there. And so as a result of that, we're going to have a trial in workers' compensation court. So in terms of I wanted to give everybody sort of a sense of how the cases, or sort of a discussion in terms of the cases themselves, in terms of potentially resolving claims. Now, the other thing is, we talk about workers' comp and Social Security and disability pensions. The thing that is easy for purposes of Social Security and the disability pensions is that there's no conferencing cases. There's no resolution without having a hearing or a trial. We, for Social Security, 9 times out of 10 will have to go the full ride and get a hearing in front of an administrative law judge, where we'll have to have a hearing, a Social Security disability hearing, and as a result of that, they will make a decision. With the disability pensions, the attorneys for or who represent the pension board, they have absolutely no authority whatsoever to make any kind of resolution. And the pension boards don't want to resolve things by making an offer to settle cases. So they basically, if they've made the decision that they're denying you, the answer is that they're just, the only way to resolve that is to have a full-blown trial and move forward. Which is interesting because you would think that, you know, if they lose after an extended period of time, the amount of money that they would have to pay in retroactive benefits is large, and if they made an offer, that might resolve the case without having to be concerned with lifetime benefits and lifetime health insurance and any number of variables that go with the pension board, well, with a win at the pension board level. So anyway, but for purposes of the workers' compensation, that's how the cases get discussed, and that's how they move towards a resolution, and that is sort of the final piece of that particular puzzle in terms of the cases actually settling. Now, if you come to a settlement, if you come to a resolution, then a judge of compensation has to approve that particular resolution on the record. So the lawyers just can't sign paperwork and call it a day. The injured person has to come to court and on the record indicate that they understand exactly what's going on and indicate that as a result of that, they want the judge to approve the agreement, at which point the judge will sign a formal court order, and then the matter will be officially resolved. The final piece of, let's say, getting to the conclusion in terms of workers' comp as far as the resolutions go is that once the court order is entered, then the insurance company or the state or whomever has 60 days in which to make a payment. And if they do not make that payment within 60 days, then there has to be a specific motion to enforce the court order that gets filed in the Division of Workers' Compensation. But again, 9.9999 times out of 10, within the 60 days, the insurance company makes the payment. So anyway, so I wanted to just give everybody a better understanding of the final piece of the workers' compensation matters. Certainly we can talk about, if anybody is interested, what goes on at a trial in workers' compensation, or I can go into further detail about how to get to that sort of conclusion point where you're discussing the cases with the judge. If you just throughout the week let me know what you'd like me to talk about regarding that topic, I'd be more than happy to do that. Also, remember, please feel free to call me at 609-771-8611, 609-771-8611, or email me at sgaylord@gaylordpop.com, sgaylord@gaylordpop.com. Send me your questions, send me your inquiries, and I'd be more than happy to put them on this show so that I can get you whatever information it is that you're looking for. So with that, live from far away, I want to wish everybody a great weekend. Hopefully it won't be nearly as hot as it has been, so that's good news. And I wanted to, again, thank everybody for joining me here Saturday morning. This is Saturday Morning with Sam. I am Sam Gaylord, managing partner at Gaylord Pop and disability litigator in the state of New Jersey, representing injured workers in the areas of workers' compensation, Social Security disability, and disability pension appeals. I want to say thank you. I want to wish everybody a great week, a great weekend, and I look forward to speaking with everybody again next Saturday morning, 9 a.m., and I should be in the office, and we'll go through some additional topics, and I'll provide you the information that you need in order to make sure that the benefits that you are entitled to receive are yours. I will talk to you then. Bye-bye.